Hello everyone, this is Sodhi from CAAN Wings Consultants Private Limited. Welcome to my weekly YouTube session. So the topic for today's session is the 5 most important questions, or let's say the top questions you've been looking answers for. The first question that the majority of the clients have is related to the spouse. Now, anybody who's thinking of applying for Australia migration, they are keen on understanding whether the spouse is required to undergo IELTS or PT or not. Of course, those who are single, it's good for them, they get a lot of points. But those who are applying with their spouses, they want to know whether it is compulsory for their spouse to take IELTS or not. So my answer to that question is that for the partners, or let's say the spouse, there are 3 options given by the Department of Home Affairs. You have to fulfill any one of the following. One is that they have to take IELTS or PTE and score an overall 4.5, which is called the functional level English. The second option is that in case your spouse happens to be a graduate with English as medium of instruction and examination, then he or she is exempted from IELTS or PT. In that case, the spouse does not need to take the IELTS or PT. And let's say there is a situation where the spouse is neither qualified, doesn't have any tertiary qualification, nor is the spouse keen or able to score a functional English proficiency score. In that case, you can always have the option of paying the second VAC charge once the application with the DHA is lodged. So to put it simply, it is not necessary, it is not mandatory for your spouse to have, to sit for the English proficiency test, as long as they have a tertiary qualification in English medium, or if they are willing to pay the fee, which is of course quite high. So my recommendation is you rather have your spouse give a shot, sit for the test instead. Now, the second question that people do have a lot of concerns over is that in order to claim points for their partner skills, what are the criteria? What all does the partner need to do in order to be able to, in order for you to be able to claim 10 points for your spouse? So there are basically 3 requirements for your partner to fulfill, on the basis of which you can claim 10 points for partner skills. The first is that the partner, your spouse, has to be below 45 years of age. Second, the partner has got to have some sort of tertiary qualification. Third, your partner should have a positive skills assessment from whatever the assessment body for the partner would be, whether it is the WEDSS or the ACS or whatever. And third and most important point is that the spouse needs to also have 6 bands in each section in the English proficiency, be it PT or IELTS. Now here I'd just like to give you an insight. Let's say you are the primary applicant and your occupation is listed on the MLTSSL. Let's go with the example of a management consultant, that you're a management consultant and your occupation is listed on the MLTSSL. And let's say your spouse is an HR professional, is an HR advisor. So in that case, if your partner manages to get a positive skills assessment, would you be able to claim 10 points? The answer to that is a no. So in order for you to claim partner skill points, it is essential that your partner's occupation is also listed on the same list such as yours. So if your occupation is listed on the MLTSSL, you will be able to benefit from your spouse's skills assessment if her occupation is also listed on the MLTSSL. Or if your occupation is on the ROL, the partner's occupation should also be on the ROL. If your occupation is on the STSOL, her occupation should also be on the STSOL. So if her occupation happens to be in a list other than your list, then unfortunately you will not be able to claim partner skills points for her, that is 10 points, having 6 bands in each section for the English proficiency score. So I hope that issue has been cleared. So the third question I'd like to come down to is regarding the verification of employment. Now, this is very, very critical. Clients, people, viewers who watch my videos often like to understand whether there's any kind of verification involved and what are the stages when they can expect a verification from the Immigration Department of Australia. So I can tell you with absolute certainty that each and every document that you submit in support of your application at any stage is subject to verification, be it your qualification, be it your English proficiency score, be it your tax returns or employment documents. Employment verification is something that is usually done at the first step by many assessment bodies. Verices being the largest body, being one, surely conducts an employment verification. Now there are cases where there are no verifications. That's on a case-to-case basis that they decide whether the application calls for some sort of an integrity check or not. So there can be a telephonic verification, there could be a third-party verification, there could be a physical verification, there could be a verification through the email, and so on. Now let's say somebody has undergone the verification process and has got a positive skills assessment from a respective skills assessment body. Does that mean the verification part is over and the applicant will not be subject to any further investigation or verification? The answer to that is a no. Once your application with the Department of Home Affairs is lodged, you can be subjected to a further very stringent verification process. So those of you who have a positive skills assessment and are probably thinking that now our skills, which is your qualification and your employment, is all taken care of, we are done and dusted with that part, please keep in mind that there can be further check, and once the DHA, Department of Home Affairs, conducts verifications, those are usually very, very stringent, very, very thorough, and you better make sure that you stand through it all at all stages. Now the fourth point I'd like to come down to is again a very common question, that is, do we really need to have a higher point score in order to stand a good chance to get skill migration for Australia? In fact, I do have a lot of clients, a lot of people asking me questions, telling me that they are coming up with, let's say, 90 points under subclass 491, 85 points, or let's say 80 points under 190, and 75 points under the 189. So what are the chances? So please let me just draw a parallel here. Let's compare the three subclasses, subclass 189, subclass 190, and subclass 491 with Canadian immigration. Let's try and compare. So a subclass 189 is something like Canada's federal skilled worker program, which is routed through the express entry, in which of course the higher your points, the better your chances are of getting an invitation to apply for a visa. Whereas the subclass 491 and the subclass 190 does not work that way. Of course, a higher score is always appreciable. However, the focus here or the criteria for your nomination here depends upon your meeting the eligibility criteria, whether the state that has set a certain criteria for a benchmark for the applications, whether you're able to meet that criteria or not. And I'd like to here very categorically state that because this is a question I've been asked over and over, how can I get in, when will I get invitation for 190? So please understand, unlike the 189 visa in which the DHA invites the high scoring application, 190 visa does not work that way. It works like the 491 visa. So under the 190 and 491 visa, you need to check in which particular state your occupation is in demand, and then whether you meet the criteria or not. And you will not automatically get a nomination. You will have to proactively apply for a nomination here. So the fifth and the last question I'm going to take up today is about the processing time. How long does it take to get a 189 or 190 or a 491 visa? Now this is a tough one to answer. Why I say a tough one? Because I have seen that a lot of times there is a variance between the actual processing time from the estimated processing time that is published by the DHA. So just to put it simply, basically 189 subclass and 190 subclass visas are not priority applications, so you can expect these applications to take longer to finalize, whereas the 491 visa is a priority visa, and you can expect this visa to be through within months. Of course, we, like I said, we have seen the processing times exceeding the published times, but this is a visa that is expected to be processed sooner than other visas. So I think I'll wrap it up here today. Please do send me your resumes. My team and I would be very keen on hearing from you. Our number remains the same, 78498 or please feel free to give us, send us your CV or your queries on email. You can email us on caanwings@gmail.com. That is CAANWINGS@gmail.com. So until next time, I'll be with you with more information and see you again next time. Bye-bye.